least you can. So as Brad said, my name is Sandy Cedar. I'm the assistant to the city manager, and I know about that much about oil and gas regulations. I am here to help our boards and commissions, give some feedback to our city council, and to help make sure that the public who has done their voting, their dot voting outside, that information comes to the boards and commissions. We have a pretty packed agenda today, and so I'm really hopeful for a great meeting. I hope you have fun with the little keypads, even though it's a very serious subject. Keypads are kind of fun. And the way that this evening is going to roll is we're going to have Brian Schumacher give a brief presentation to the boards and commissions who are sitting around the dais. Thank you all for coming. We certainly appreciate you spending the evening here. And then we will, and as Brad said, we have a public invited to be heard sign-up sheet out there. We will do a brief question and answer from the boards to the staff presentation, and then open it up for public invited to be heard so that the boards can hear pretty much anything you'd like to say for that 3 minutes. In the meantime, while that's all happening, I have already counted all the dots outside, and we'll get that information to the boards also so that they have that when we are asking them similar questions around what they would like to see the city council do around oil and gas regulations. So there are a couple of, I would say that they're nuances, but they're much bigger than nuances. They're kind of like short brick walls around oil and gas. One of the things is that the city council is the decision maker in this whole process as far as they can. What you're going to hear from Brian, and you probably already know, is that there are some things that the city is likely preempted on as far as regulations, and that may not stop the city council from trying to do those regulations anyway at some sort of litigation risk. So you're going to hear more about that, but just understand that in this case, the boards and commissions are at an involved level of community involvement where they are giving their feedback to planning and zoning and to the city council. You are all in a consult level of community involvement, which means that you all voted with your dots. You're going to be able to have your 3 minutes to speak to the boards, who will then give their recommendations. So we'll have kind of 2 sets of things going to council. If you all saw the half sheets of paper that were out there, the half sheets that said, here are your comments, take an opportunity to write what you'd like your city council members to know. We're going to take those and copy those directly, scan them for them so they can see your comments directly. So if you decide that, hey, public speaking really isn't for me tonight, feel free to take one of those comment cards and just really fill it out so that we make sure that we get your comments directly to your city council members. The city council takes this extremely seriously. The boards and commissions that are dedicating their evening here tonight obviously take it extremely seriously. This is an issue that has come up very quickly on the legislative scene, and so we want to try to get input in a meaningful way that really involves as many people as possible, recognizing that there may be some serious limitations that the city council has in front of it with respect to this issue. So after the public invited to be heard section, then we have the Who Wants to Be a Millionaire Ask the Audience part. So all of our board and commission members have one of these fancy keypads. Everyone has one of these near them somewhere. Don't touch them yet, but they won't explode. It's not one of those. But who here has seen Who Wants to Be a Millionaire? Do y'all remember that show? Yeah, okay, it's not just me. I see some of you wanting to raise your hand. So Who Wants to Be a Millionaire? When the person was up there, they could ask the audience, and it polls the audience. That's what these keypads are. It's the same technology. So the boards and commissions will be asked to weigh in on, I think we have probably 15 questions or so, and so you'll be asked to use your keypads to do that. We'll explain how that works a little bit. That feedback will be tallied by board so that we can give that information to the city council, and as I said, the public input will be tallied during Brian's presentation so that you'll have that. So from the boards and commission members, do you have any questions on the agenda for today or how this is going to run? All right, very good. Well, I'm going to turn it over to Brian Schumacher, who's going to give a presentation to you while I go print out what the dots were.
Welcome, everybody. I'm Brian Schumacher with the Economic Development Department, Senior Planner. I know you all got a packet. There's quite a bit of information. There's a kind of a 14-page summary of information about background information on oil and gas, some of the legal issues associated with it, as well as what some of the other jurisdictions are doing, taking a look at, and then some of the areas that we're currently looking at, topical areas and some of the issues that we've run across. So Jane, would you mind turning on the projector? Thanks. So I've got some slides that follow along pretty much for the benefit of the board members as well as the members of the public. Follows along with the narrative and the packet of information that you received. And we can certainly talk about that if you have questions regarding any of those particular items. So this is just a quick outline. I'm going to try to be fairly brief on each of these slides in the interest of time so that there's plenty of opportunity for discussion, not only by the boards but also by the public as well. And so we've got a number of staff here. I'm not going to go ahead and introduce everybody, but there's staff from our legal department, economic development, public works, and natural resources. So if there's specific questions that I might not be able to answer, there's other staff that probably help out on that as well. We'll talk a little bit about the purpose of the meeting, the schedule, not only for upcoming meetings, but prior to the expiration of the moratorium in April. Give a little bit brief overview on oil and gas, some of the preemption issues that we've been discussing with respect to local regulations and cases that have determined that certain items are preempted from local regulation. I'll briefly touch upon some of the other jurisdictions, either their existing regulations or regulations that are in process or have been recently determined. And then some of the attachments that you received in your packet were copies of letters from either the state Colorado Oil and Gas Conservation Commission director or the Attorney General's office in response to other jurisdictions' draft regulations. I'll give you a brief overview of some of the areas that we've been looking at, and then talk a little bit with the boards, and that's kind of part of the focus of the survey will be with respect to some of the topics and issues that we've been examining as we've looked at different issues associated with the drafting of the regulations. So in terms of the purpose for the meeting tonight, obviously we'd like to get as much input as possible from the boards and public on the topics and issues associated with oil and gas regulations. That includes some survey questions. We've had those questions as part of the open house earlier in the afternoon from 4:30 to 6:30, asking the members of the public to put dots by their responses in terms of their preferences. We've handed out comment cards, as Sandy mentioned, that will be forwarding that information to City Council, as well as just the general discussion of this meeting as well. And then that information will be forwarded on to City Council to help frame our discussion and the community's concerns regarding oil and gas issues. So in terms of the schedule, the council adopted the moratorium. The actual ordinance was adopted in January, but it was effective December 20th when they made a motion to enact the moratorium. And it extends for 120 days through April 17th. And in terms of process, we have the joint board meeting this evening. We have a Planning and Zoning Commission meeting next week on February 15th, where we'll be talking about the draft regulations. There'll be a City Council study session meeting on the 21st. And then at that meeting, we want to get direction from City Council in terms of crafting an ordinance for their consideration. And if Council gives us direction to move forward with the drafting of the ordinance, we anticipate submitting that to City Council on March 13th for first reading and introduction, and then the hearing on the 27th of March in anticipation and prior to the expiration of the moratorium. In your packets, and I'm certainly not going to go into detail, there's background information regarding the Oil and Gas Conservation Act that was enacted in 1951 by the state legislature. And as part of that, the Colorado Oil and Gas Conservation Commission was formed to put together regulations and processes in terms of reviewing and taking into consideration some of the issues associated with oil and gas development in the state of Colorado. And with respect to oil and gas activity in Longmont, I know other jurisdictions along the Front Range have had quite a bit of more experience than the city of Longmont has with respect to oil and gas activity. Within the city limits itself, we have 12 existing producing wells. Compare that to, for example, Greeley, which has, I believe, a little over 400 existing wells within their city limits. Since our regulations were enacted in 2000, we've had one well drilled, and that was on the Sandstone Ranch property, the Evans 6 well, which is south of the Morris Kaufman Visitor Center house on the Sandstone Ranch property. With respect to recent interests, we've had discussions with Top Operating Company, which owns a number of the mineral leases on city-owned parcels, and they also own some mineral leases on privately held property as well. And with city's acquisition of properties in what's referred to as the greater Wattenberg area, Wattenberg Field, and if you were out in the lobby, there's some maps that show the number of wells that have been drilled within that Wattenberg Field. And in the Weld County alone, there's been over 17,000 wells drilled within that area. With our acquisition of properties around Union Reservoir for open space and future expansion of Union Reservoir, as well as parkland and open space land south of Highway 119, we've expanded more so into the greater Wattenberg area, where there's been a lot of drilling and exploration activity. And so as a result, we're seeing more interest from mineral leaseholders for potential drilling operations on city-owned properties, as well as other properties that might be within the city of Longmont. So I just wanted to mention a little bit about the preemption issue and local regulation. And there's a good outline in the narrative that talks in a little more detail and outlines some of the case law with respect to preemption. But just in summary, this slide outlines those areas that have been ruled where local governments are preempted by enforcing local regulations by the courts on various cases, and that includes a complete ban of drilling, setbacks, noise, visual impacts, fine and local enforcement of state rules, financial requirements for areas that are covered by the state, as well as inspection of records. The next slide talks about areas where it's not exactly clear whether there's preemption of local government regulations. And those are things such as lighting, drilling and completion, fracturing fluids, closed loop pitless systems, waste containment, water quality monitoring, and wildlife and habitat protection. So those are kind of what's referred to sometimes as the gray areas. And then we've got other areas where local governments are considered to have authority, and that's local government review, where the local governments have the ability to put oil and gas operations through their local review process, transportation and access issues, as well as emergency response. So in terms of some of the research that we've done with respect to looking at regulations, not only existing regulations that other jurisdictions have on their books, but also draft pending legislation that other jurisdictions are looking at. It's varied substantially from jurisdiction to jurisdiction, depending upon whether or not they are experiencing any type of oil and gas exploration or drilling activity. There's several jurisdictions, and we cited Loveland as an example, which they currently don't have any oil and gas regulations in place in their zoning code. Two other jurisdictions have substantial regulations, and some of the more restrictive regulations that we've run across are counties in the southern and western Colorado, Saguache, Rio Grande, La Plata, and Gunnison counties. And then some of the jurisdictions that have less restrictive regulations that we've experienced are Greeley, Weld County, Frederick, and Broomfield. As noted in the narrative, both Frederick and Greeley have been subject to court cases with respect to their prior regulations. Greeley was subject to a case where they were preempted from a total ban of oil and gas drilling within their jurisdiction. And then the Frederick case addressed some preemptive issues regarding setbacks, visual mitigation, noise issues. Weld County, obviously, they've experienced a lot of oil and gas drilling operations, but for the most part, their regulations pretty much mirror the state's regulations. They do have most of the area is agricultural in Weld County, and most of that is a use by right. In some of the other zoning districts in Weld County, they have a special use review process that they utilize, but the vast majority of the well permits that are issued in Weld County are through a use by right process. And then Broomfield's are also experiencing quite a bit of oil and gas activity within their jurisdiction. I would say that Greeley, Frederick, and Broomfield's regulations are not substantially different than what the City of Longmont's regulations currently have on the books. And so when we look at other jurisdictions that are considering new or updates to their oil and gas regulations, there's several, including Longmont, that have imposed moratoriums. We've got El Paso County, which had a 120-day or 4-month moratorium that just recently expired on January 31st with adoption of their scaled-back regulations. Colorado Springs had a 6-month moratorium in place that I believe extends through May. Boulder County just recently enacted a 6-month moratorium. City Council is kind of working through on a rolling 30-day moratorium, and they have a working group that's working through issues with respect to items that they'd like to see addressed, and potentially that may come back through a memorandum of agreement or understanding with the state as opposed to updated regulations. And then obviously Longmont as well, which our moratorium extends through April 17th. With respect to either jurisdictions that are either exploring or have explored updates to the regulations, there's a list of the various counties and municipalities that either have or currently are taking a look at different options. Arapahoe, Douglas, El Paso, and Elbert counties had all previously released their draft regulations. And those four, and those are attached to your packet, received letters from either the Director of the Colorado Oil and Gas Conservation Commission or the Attorney General's office with responses to the draft regulations. Arapahoe County in January voted 3-2 not to approve their draft regulations that have been recommended by their Planning Commission. El Paso County on January 31st voted 3-2 to approve a substantially modified version of what their draft regulations were recommended by their Planning Commission as well. The 4 areas that they included in their draft regulations was transportation impacts, noxious weed management, emergency response plans, and water quality monitoring. The other aspects of their regulations, they decided not to adopt those, but they asked staff to work with the state Attorney General's office and the Colorado Oil and Gas Conservation Commission to see if they could work out a memorandum of agreement regarding their other areas of concern as opposed to adopting those as part of the regulations. Douglas County, they've had their regulations out for public review since, I believe, October. And they have not yet scheduled public hearings before their planning commission and Board of County Commissioners. Elbert County was the most recent county to get a letter from the Attorney General's office. And at one point last week, they had some dates for review by their Board of County Commissioners in mid-February, but that's been taken off the schedule. And my understanding is that they are forming a committee to look at some revisions to their draft regulations. So basically, all four of the letters have been pretty similar in terms of the different areas that either the director of the Colorado Oil and Gas Conservation Commission or the Attorney General's office has highlighted areas where they feel that the local jurisdiction's draft regulations are preempted or potentially preempted by state rules or previous court rulings. And I noticed that in the last line on the Elbert County letter, which was dated last week, I believe, indicated that the COGCC, Colorado Oil and Gas Conservation Commission, they had a recent announcement of a public stakeholders process to review the setback issues. So they are getting some, obviously, pushback on that particular issue. I don't have any specifics yet in terms of when that'll be moving forward in terms of a process, but it's certainly something that they're going to be looking at in terms of the statewide, and I don't know if they'll be looking at the high-density area setbacks as well, but it will be one area of focus. And then just briefly, with the state legislation back in session, there have been 4 bills to date. There might have been likely more that will be introduced with areas addressing certain aspects of oil and gas. The 4 bills that have been introduced to date are severed mineral rights, address statewide setback associated with hydraulic fracturing, and I believe that particular bill would impose a 1,000-foot setback from any well that would be utilizing hydraulic fracturing. And then there's one of the bills requires a closed loop system. And then the other one, which is the first 3 are House bill, and then the last one is a Senate bill, which is pretty much a total preemption of local jurisdiction regulation in oil and gas development. So in terms of the City of Longmont's existing regulations adopted in 1990, no, that's not right. Let's scratch that. They were adopted in 2000. That's a typo on my part. So they address a variety of topics. Most of those issues address primarily visual impacts and to a lesser extent some nuisance issues such as noise, setbacks, and not as much in terms of environmental impacts. And so when council directed staff to kind of fill in the gaps with respect to some of the areas that we currently had holes or didn't have check marks in terms of areas of regulation, those are some of the areas that we wanted to focus on. Our current regulations require conditional use review in all zoning districts except the mixed use district. And actually the mixed use district, that was left as a district where oil and gas wasn't allowed because the mixed use district at the time it was implemented or adopted was anticipated to be primarily along already developed areas in the Main Street corridor. So there would not be opportunities for oil and gas, obviously, in those areas. So the conditional use process is a public hearing process. It requires a neighborhood meeting up front before an application is submitted, staff review, as well as a public hearing before the Planning and Zoning Commission, which is the decision-making body, unless that decision is appealed to City Council. With the regulations update, we're trying to approach this from a balanced perspective in response to Council's direction in terms of trying to fill in the gaps where we might have areas that we haven't addressed. And then we're also attempting to reduce the likelihood of legal challenges with respect to the regulations that are adopted. And so the next number of slides, and I promise it won't be too long, will be with respect to the summary of some of the topics and issues that we are looking at as we draft the regulations and exploring different options. So in terms of the review process, one of the things we've looked at is trying to allow for or to encourage the implementation of some recommended standards or enhanced standards in areas where local jurisdictions, local governments may be or are preempted by state law or state rules. And so with that respect, we've looked at options in terms of having a public hearing process for those areas where an applicant may only meet the minimum requirements, or they may meet some of the recommended standards, but not all of the recommended standards. And if an operator were to meet all of the recommended standards, then potentially they could go through an administrative process. We would view that as an incentive to encourage an operator to implement all the recommended standards. That would be a goal for the community. Another aspect of the review process would be to implement third-party technical reviews on areas of applications or variance or exception requests where staff may not have the expertise, that we could have a third-party expert take a look at those areas and provide the city with their input in terms of the review of those applications and or any types of variance or modification requests. In terms of zoning, there's prior case law with regard to the Greeley case that local governments are preempted from a total ban on oil and gas drilling within their jurisdictions. Areas that we've been looking at are zoning district restrictions, whereby if we're not able to prohibit a particular operation completely within the city's jurisdiction, that we might be able to restrict those to a particular zoning district or zoning districts to help minimize potential impacts. And an example that was included in the narrative was the use of injection wells, Class 2 injection wells for waste products. Whether or not the city could ban those or restrict those to industrial zoning districts, that's an area that we're taking a look at. In terms of inspection enforcement, again, this is an area that's been, particularly the enforcement area, been preempted where the state has an interest, but the city has the ability to inspect local land use areas, such as areas where the city issues building permits or transportation permits associated with that. As mentioned in the narrative, the County of Gunnison recently entered into a memorandum of understanding with the Colorado Oil and Gas Conservation Commission regarding inspections of oil and gas facilities within their jurisdiction. And I know that the Gunnison County had some issues or concerns about the frequency or infrequency of inspections on the oil and gas facilities. So they worked with the Colorado Oil and Gas Commission to work out this memorandum of understanding whereby their inspectors could be trained by the Colorado Oil and Gas Commission, but unfortunately they would not be able to have enforcement authority under that memorandum. But it's still a first step in terms of being able to have more inspectors out there on a regular basis to try to address issues to the extent that they can and notify the state of potential issues that they might foresee with respect to oil and gas operations under their jurisdiction. In terms of notification, that'll be one or two of the questions that's part of the survey that's asked a little bit. One thing that we'd like to work with the state on is additional notice. We currently receive notice as a local government designee for drilling operations, but in terms of other activities, whether it's spills that might occur or remediation efforts, we currently don't receive, unless we were the property owner, notice of those particular activities. So as part of a potential memorandum of understanding with the state, that's one area we'd like to work with them on. And then another area that we want to have some discussion on is whether we'd be able to have either the state or the oil and gas operator provide notice to surrounding residents regarding potential issues of impact regarding oil and gas drilling operations or spills or remediation efforts. With respect to setbacks, again, this is one of the areas that was preempted in the town of Frederick case. The state setbacks, there's a couple of levels. One is the statewide setback, and a statewide setback is only 150 feet from the wellhead to a building unit or a roadway or a railroad or a major utility line. And a building unit can include a residence, can include a unit within a temporary housing. It also includes commercial buildings as well as industrial buildings, depending upon the size of the buildings. There's also high density areas, and that was a regulation that was adopted to try to address the impacts associated with oil and gas drilling in more urbanized areas, whereby if an area can meet the high density criteria, and that's a certain number of building units within a 1,000-foot distance radius within a proposed drilling site, I believe it's 36 building units, that there's additional setback requirements of 350 feet as opposed to 150-foot statewide limit. And there's also, in addition to the 350-foot setback, I believe that's for wellheads, there's also the 500-foot setback from production facilities such as storage tanks in high-density areas. There's also a process whereby the state, Colorado Oil and Gas Commission, can designate outside activity areas. And those are areas, gathering places, such as playgrounds, parks, trails, other areas that receive a substantial number of public activity in those areas, and there's certain criteria, a certain number of people over a certain number of days in order for an area to be considered as a designated outside activity area. To date, the only designated outside activity area that we're aware of is in the whole state is part of Sandstone Ranch, the existing ball fields on Sandstone Ranch. So it's not an area that the commission has designated on a regular basis, certainly. So that's one area that we would like to potentially pursue, is taking a look at some of the other areas within the community that on a regular basis have activities occurring, whether that's trails or ball fields, playgrounds, whatever that might be, golf courses, potentially could be designated as outside activity areas. The City of Longmont's current standards are 350 feet setback from occupied buildings. We also have a 75-foot setback from roadways. So our existing standard is out of compliance with the statewide standard, but it would meet the standard for areas that are classified as high-density areas. So with respect to setbacks, we're looking at some options in terms of minimum standards as well as recommended standards for setbacks. Noise and lighting. Again, in the town of Frederick case, noise was an area that was preempted in that particular case. The state does have noise level standards, and those are not substantially different from our current noise level standards. Our existing oil and gas regulations exempt drilling operations from nighttime noise limits. And the state lighting standards address primarily glare. They don't address lighting levels or intensity. A couple of things that we're looking at is various mitigation options, both for noise and lighting mitigation, not only at the time of drilling, but afterwards in terms of production facilities. Again, not to be repetitive, but visual mitigation is another area that was preempted as in the town of Frederick case. Under our current regulations, we actually have quite a few standards with respect to visual mitigation. They include recommendations in terms of location of oil and gas facilities, screening, landscaping, fencing, and painting. What's interesting is that even though this is a preempted area, the only state standard is the painting of facilities to have the facilities blend in with the kind of landscape background where the facilities are located. So again, in this particular area, we're looking at some options for visual analysis and mitigation options associated with oil and gas facilities. In the area of drilling and completion, fracturing fluids, our existing regulations don't address this particular topic. As some of you may be aware, the state recently adopted a rule on hydraulic fracturing chemical disclosure. There is a provision in there with trade secret protection. That rule goes into effect on April 1st. And as part of the update, we're looking at some recommended standards for this particular area. Closed loop pitless systems in terms of drilling and waste disposal. Again, this is an area where existing regulations don't address. With respect to the only gas operation and permit that was reviewed through our current regulations on the Evans 6 well and Sandstone Ranch, there were pits used in conjunction with that operation. Some of the contamination that can occur on well sites is often associated with historic pit operations that have occurred with oil and gas operations. On a positive note, the trend is for operators more and more using closed loop systems, and so the majority of operations that are occurring are utilizing closed loop systems. And so we're intended to incorporate recommended standards with respect to closed loop systems in the recommendations and the draft regulations. Water quality monitoring, our current regulations don't address this area. The state has some rules for the greater Wattenberg area, which outline which and when existing wells can be used for testing subsurface water sources. However, there's an exception in the rules that if there's no water quality testing wells that meet their criteria, then the initial baseline testing is not required associated for water quality monitoring. So we're hoping to, excuse me, pardon me. So as part of the draft regulations update, again, we're looking at some recommendations and standards regarding water quality monitoring to incorporate in the draft. Regarding wildlife and habitat protection, our existing regulations do reference the citywide wildlife and habitat protection standards that we have that apply citywide for all developments whereby we can require a habitat protection plan and mitigation where appropriate, where there's potential impacts associated with wildlife and habitat. They also address setbacks associated with development that might occur near rivers, streams, riparian corridors, and wetlands. And our current setback standards in those areas are 100 to 150 feet in terms of buffers for development that might occur near those types of water bodies and wetlands. And the state also has some standards with respect to wildlife and habitat protection that was adopted I believe, in 2008, some recent rules that address habitat areas and restricted surface occupancy areas that are indicated on their state maps that are on the COGC website. And I'm getting close to the end, so bear with me. One of the final areas that we're examining is financial assurances. This is an area that was preempted in the Gunnison County case in terms of being able to require financial assurances in areas where the state already regulates. So the COGC addresses financial assurances or securities in areas such as reclamation, soil protection, plugging and abandonment of wells. Some of the areas that we're looking at with respect to providing financial assurances or impact fees would be areas such as transportation impacts and possibly other areas that are not covered by the state. So, next steps with respect to this evening's meeting is to take questions from the board. And after that, we'll invite the public up to speak at this seat. And there's a 3-minute time limit for each member of the public who's signed up to speak at that time. And then after that, Kim Sugar will operate the control panel for the for the survey. We'll also, prior to that survey, we'll report back on the open house results in terms of the survey's questions that were asked then. So, sure. Okay, sure.
So this is your opportunity to ask Brian any questions that you have.
And not just me, but anybody on staff.
Yeah, hi, Brian. You mentioned potential zoning regulations, but it was specific to Class 2 injection wells. Can you talk a little bit more about that? Were you thinking there might be leeway to put in some restrictions for drilling for, say, an industrially zoned, for anything that's not industrially zoned? Or what is staff thinking on that?
So there's certain types of operations, and I mentioned we mentioned in the narrative about the injection wells as an area that we, if possible, we wouldn't like to have in the community. We're not sure if we can completely ban those types of operations. So if it's not possible to ban them, at a minimum, we like to restrict them to areas where potentially would have less impact, such as a heavier industrial or general industrial zoning district. We're also talking about whether or not, whether oil and gas operations can be limited or restricted in residential districts, for example. So that's something we've also been talking about.
Actually got 3 questions, Brian. And by the way, good job on this. There's a lot of thought and effort went into this, for sure. My first question is, you mentioned a couple times in your document here that mixed use, there's a prohibition in drilling on mixed use. Is that a city mandate or a state mandate?
It's when we updated the table of uses, when the mixed-use district was adopted in 2009. The original thought was that the mixed-use district would be implemented in areas in the downtown area along Main Street, the North Main area, perhaps part of the downtown area and South Main. That was the original intent or thought process for implementation of that. As we've continued our discussion on the concept of mixed use in the community, there may be other applicable areas where mixed use could be implemented. So at the time the mixed use district was adopted, and we were thinking that it would be implemented along Main Street where there's already the built environment, there would not be opportunities for drilling in those areas just because of the area's been built out. There isn't sufficient vacant parcels in order for a drilling operation to comply with setback and other requirements in those areas. So that's why it was not included as an area where drilling could occur.
So that was a city decision, not so it
that's correct.
Hasn't stood the test of case law yet. Then,
there have been some jurisdictions that obviously a total ban of drilling is preempted as outlined in the Greeley
I was
case.
thinking if it was state and somebody didn't want their property drilled on, they could designate mixed use. All right. Another question is, and I don't know if this is maybe more for Eugene. Preempted on record inspections. What is record inspection? Is that the trade secrets type of inspections? Is that operational records inspections? What kind? Can you elaborate more about what that means?
I think it's probably both in terms of, and I don't have the specifics, and maybe Eugene could elaborate a little bit about that particular case. But I think in that case, and I think it's the Gunnison case, whereby as their local regulations, they were asking the operator to provide information in terms of their operations and and perhaps some of the chemicals that were being used in terms of their operations as well.
Howdy, members of the board. Eugene May, City Attorney. My recollection of the case was that it would be more the operational records, and the state COGCC was the entity designated in the regs to have access to those records. The county was trying to also add it to the list of entities that would have access to those records, and the court came out that they were preempted from doing that.
Okay, thanks. My last question has to do with the MOU with Gunnison. Obviously, the city can do inspections on a site, but they can't pass the cost on to the applicant. My question is do we know what the cost on a well, on a per site basis, what it would cost to have an inspector?
We haven't really determined what that cost might be, so that's something we'd have to take into consideration if we were to move forward with a MOU with the state in terms of inspection, in terms of what those impacts might be on our existing resources, and that's one of the questions that we have for the board this evening.
Thanks, Brian. Thank you.
I have a couple questions regarding water. First of all, Union Reservoir has the potential to become a municipal water supply with the pump back project. It's currently not listed as a municipal water supply. Has that been considered in the process of evaluating the well sites around there?
In terms of the potential designation?
The setbacks are different
right.
related to municipal water supply areas. And as Union may eventually become that, I was wondering if that had been considered by the city and trying to establish that as a potential.
I know we've talked about that, since it currently isn't designated and we don't know the time frame of, and maybe Dale, you might have perhaps some insight into that. But you're right. I mean, obviously, if an area is designated as a public water supply, there's 3 tiers. There's a kind of an internal buffer of, I believe it's 300 feet where no drilling activity can occur. There's another buffer, kind of intermediate buffer, where there's certain criteria that need to be met for oil and gas operations to occur within those areas. And then there's an outer buffer where there's additional criteria with respect. And I know in the intermediate and I believe the outer buffers, the closed loop systems are a requirement in those buffer areas as well. Dale, I don't know if you have anything else to add.
Dale Rademacher, Director of Public Works Natural Resources. So, John, the other thing I think we would obviously consider and look at is whether or not in any future regulations or in surface use agreements, whether or not we can, either through regulation or through negotiation, get those types of setbacks. I think that would be in the interest to certainly look at trying to do that. From a regulatory viewpoint, though, I'm not sure if we can do it with a prospective possibility of the reservoir, but I'm sure that's something we would, again, look at and see if it can be implemented or not.
The first phase of that project is pending, correct?
The first phase, which takes it up to just the east side of Longmont, and again, that's just for irrigation at that point. It's the fourth and final phase that could extend it to the treatment facilities.
Okay. Second thing, the EPA Section 1425 of the Safe Drinking Water Act exempts oil and gas-related injection programs and basically sets guidelines for states to promulgate their regulations. Who has done that in Colorado? What agency? CDPHE or whom? As it relates to gas and oil development.
I believe that is, I have to double check, but I believe that is the Department of Public Health and Environment that regulates those.
So that aspect of it is regulated by them versus Colorado Oil and Gas Commission?
I'm just checking around to see if anybody else recollects. I believe it is the Department of Health and Environment that regulates that, but I'd have to double check on that.
It'd be a good thing to know.
Sure.
Last thing I had was sensitive area determination, not wildlife related, but it was stated that a special area determination could be required. What is the criteria for that? Anybody know?
Are you talking with respect to the outside activity areas, or
no? It's called a special area determination. It may include wildlife. It may include
for
others.
Wildlife areas.
I think it was too broad. I think it might include other things. Anybody know?
You know, I know that with respect to the legislative changes that occurred in 2007 with respect to wildlife protection and the rulemaking process that the COGCC went through in 2008 to incorporate those rules regarding wildlife protection. I know at the time the COGCC worked with the Colorado Department of Wildlife and Natural Resources to come up with those state maps that outline those specific areas. I would imagine any amendments to those would have to go back through the COGCC process for any type of amendment.
It wasn't clear to me whether that was just wildlife related or other issues in terms of sensitivity. waterways or things of that nature?
My recollection that it was primarily related to wildlife
And most of those
and
are,
the habitat associated with wildlife.
the map indicates almost all of those are west of here.
That's correct. You're right.
Yeah, okay, thank you.
I think
Regarding question 15 on the boards outside, as an incentive, if operators agree to meet enhanced standards such as setbacks, do you support using an administrative review? I noticed that I was surprised that got so many negative responses, and I can imagine that part of the reason for that is that the public input is then reduced. Have you thought of any ways to make this more palatable to the public? Because it seems like a good approach to getting operators to comply with our wishes.
You know, I was surprised by the results on that particular board as well, and maybe there's some confusion about it. Maybe there was just a level of misunderstanding or mistrust. I don't know exactly, but I think we probably need to do a better job of trying to explain how that could be a benefit to the community, of working with operators to get enhanced standards in exchange for being able to go through a shorter process and without having to go through a public hearing process, particularly for those areas where obviously we're preempted by state law. And if we're able to work with an operator to get greater setbacks or noise mitigation or wildlife protection or whatever those standards might be, I think the trade-off of having a shorter process for enhanced setbacks would be worth that for the community. If we're not able to impose standards for those preempted areas, as opposed to having recommended standards, as opposed to minimum requirements.
Well, good. I hope we will see more discussion on this then.
Certainly.
Another question, you mentioned that some areas of preemption were gray areas, were unclear. Lighting, drilling, and frac fluids, closed loop. Why are those unclear? What?
Well, they haven't specifically been ruled through a court case to be preempted as to specifically negatively impact the ability of a oil and gas operator to explore or produce oil and gas from their drilling operation. So those areas they're outlined in more detail in some of the court rulings, particularly I think it was the Gunnison case, or maybe it was the Gunnison case, whereby some of those areas that were kind of gray areas that were not found to be outright preempted, that in order for there to be some finding with respect to that, at that particular case, there was going to be at one point in time an evidentiary hearing with respect to those particular areas, but there never was that particular evidentiary hearing on those particular areas, so there wasn't a final ruling in those particular areas. Would you care to elaborate, Eugene?
Hi, once again, Eugene May, City Attorney. So Brian summarized it pretty accurately that there are a few specific areas where there is appellate case law which is binding on other courts in the state of Colorado. And the case law has developed a test to see whether a certain local ordinance would be preempted, and that is whether or not there's a technical or operational conflict which materially impairs or frustrates the purpose of the Oil and Gas Conservation Act. Unfortunately, the case law doesn't really explain how to apply that test. And the Supreme Court has said it needs to be determined on a case-by-case basis and through an evidentiary hearing. And so we don't have a lot of other examples where that evidentiary hearing has occurred. And so for those areas where there is no appellate case law, we categorize those as uncertain.
Thank you.
We can just have just a couple more questions, and we're going to roll into public invite to be heard.
In light of the events that have gone on with the Attorney General or the GOCC coming back with the local municipalities or counties or whatever with these, go back and do it again. Have you thought about kind of reconsidering an approach of going forward with an MOU first and getting things kind of in place? It seems like in terms of the effective use of city resources and that kind of thing, as opposed to this thrashing back and forth of, yeah, you're out of compliance and maybe you can do something here and this is a gray area. It seems like that approach taken by the one organization of getting an MOU in place might be an approach to save time, resources, and get to something that would be defensible.
You know, that's certainly the direction that Arapahoe County and El Paso County are going with respect to their areas of concern. Obviously, Arapahoe County didn't adopt their regulations. El Paso County had some pretty substantial regulations drafted that went through their planning commission, and the planning commission recommended approval, and subsequent to the county commissioners receiving the letter from the Attorney General's office, they substantially scaled back what they adopted last week. And so they're looking at the MOU process as an avenue. The approach that we're taking, obviously the MOU is certainly an option, and we want to have that conversation with our city council. And from the standpoint of looking at issues, the preempted issues that have been outlined in the various Attorney General office letters, that's how we kind of formulated this concept of trying to provide some type of incentive for those areas that might be preempted to encourage operators to go the route of providing enhanced standards or complying with enhanced or recommended standards on a voluntary basis in exchange for being able to go through a shorter review process. So, yeah, we're exploring all options. It's not off the table, certainly.
Brian, I was going to ask, has there been any attempt by local governments in Colorado to sort of coordinate to some extent and potentially, speak to the Oil and Gas Commission collectively, have a little more sway that way?
There was a meeting of a number of jurisdictions a couple of weeks ago out in Del Camino with some of the communities along the Front Range to talk about some of the issues that they were running across with respect to oil and gas development, but it hasn't gotten to the level yet of kind of working together to talk to the state, but that might be something to consider and take a look at.
Okay, if you are all comfortable, we're going to go ahead and move on to public invite to be heard. Everyone all right to move on? If you are a board member of one of these three boards and you are sitting in the audience, now would be the time to come and join us. So come on in and join this circle so you can hear public invite to be heard. After public invite to be heard, we'll take a brief break so we can get the option power system up and rolling. At that point, we'll take a roll call and then go ahead and go through with the voting. Just to make it easy on everyone, I'll go ahead and call the names for a public invite to be heard, and Jane will be running a 3-minute timer, which I hope we'll make sure you can see. And we'll start off with Dwayne Lees, followed by Judith Blackburn.
Hello, my name is Dwayne Lees. I live at 26. 2686 Pearl Howlett Road, Longmont, Colorado. I live out east of town, right close to County Road 5, and we have a couple of areas that have, sites that have been fracked out there. There is a tremendous amount of activity that's involved with this, as you probably all very well know. I want to make this short and to the point. One, don't be afraid to extend the moratorium. Go to the mat. This is too important. Working together with other local jurisdictions, I think, is a great idea. There's got to be pushback here. Think about it. We could have a gas well in Roosevelt Park. You like that? With the batteries right there. Trucks lined up, and I experienced this out where we were at. Trucks lined up 24 hours a day, at least 3 or 4 deep. 18-wheelers. The very same roads that they were on have had to been patched because they are just the weight of those trucks on the roads caused damage. And this spring, all of those got repatched in about 5, 6, 7 different places. So I just want to make this short. Don't be afraid. The people, I believe, are on your side, on all of our sides. This is about life. It's not about money. We have to dig deep here. Get down to basic core values. Stand tough. Stand tall. We've got to do this. It's up to us. This is our place. This is our time.
Thank you, Dwayne. Next up, Judith Blackburn. After that, Dale Lannon.
Judith Blackburn, 3724 Oakwood Drive in Longmont. I'd like to second everything the previous speaker just said. After months of research, information gathering, and testimonies by affected Longmont homeowners, suggestions offered by various citizens to city council members and city staff seem to have been more or less ignored in a rush to reinforce what I think is a very problematical notion of preemption, that the so-called rules of state regulatory commissions override community rights and interests. Even this huge packet distributed this evening seems to have an underlying message. Alas, there's nothing we can do. As though open space, lands, parks, schools, and urban settings are appropriate for heavy industrial development of the sort that accompanies these newer developments in directional fracking technologies with their wasteful overuse of water and potential for harmful spills. The only thing that is clean about this method of extracting oil and gas energy is the moment it is burned for fuel. There's nothing clean as it is blasted from the earth, nor as methane escapes from the fracking sites, nor about the long lines of heavy fossil-burning fueled trucks servicing the sites. Nothing clean about the noise and overbearing lights burning 24/7 at fracking sites. Our worries are not just about spills, though the industry's ability to monitor itself has been repeatedly proven to be inadequate. But we worry about the presumption at this time in U.S. history that large corporations, through massive PR campaigns, buying the influence of lawmakers, plus the threat of prosecution, are overwhelming those who should be defending our rights to health and safety. Mr. Schumacher mentioned one of our goals being to reduce the likelihood of a legal challenge. But I urge you board members, at a minimum, to recommend challenges of that sort. Extending the brief moratorium in place on accepting oil and gas permits, and if regulations are to be adopted earlier, then to recommend a minimum of at least 1,000-foot setbacks and closed-loop systems within the city. And I hope you will join us in warning City Council that the citizenry is awakening to the seriousness of this issue. If Council can't see their way to stand strong against a determined and powerful industry in defense of citizens, the citizens will take the stand themselves. Thank you.
Thank you, Judith. Dale Lannon, followed by Stacy Welding.
Hello there. Dale Lannon, 1018 Ponderosa Circle here in Longmont. Thank you, board members and public and city officials. My position is the earth. I would like it to live for my children and for others, and for nature, for future generations of all living things. I'm going to set out a proposal to back up the city at a grassroots level, a movement towards adopting an act of God to stop, to rewrite, to cause a pause, to be able to rewrite contract in order to keep the rules of preemption from having us have to go through all these long meetings feeling like there's nothing we can do. There is. So I'm going to establish the global warming potential of methane in particular, and I'm going to establish the quantities of vulnerable gases that are starting to release, and also the effects that are accelerating in the heat potential increase of the Earth in the last few years. First is, I think I'll go for the size of the reservoir of methane. In the Arctic, there is, just in this last year, evidence of surface breaches of hundreds of meters in diameter where methane is venting directly to the surface, and this was not evident in the years previous. The potential size of the reservoir in the Arctic is huge. In the permafrost on land, 1,700 gigatons of carbon equivalents. On the methane released from clathrates is huge. Worldwide, it's 5,000 gigatons. I'm sorry. Methane potential, global warming potential, is 72 at 20 years. That's what was accepted at the UN convention for that. And but that's up to at 72 at 20 years out. That's up to 105 when you take in aerosol effects of methane release. You have a potential disaster here of biblical proportions, and I propose, Eugene, that you check out, our city attorney, check out the act of God as a writ of law when a situation becomes unexpectedly untenable to the sustaining of life on earth. Thank you.
Thank you, Dale. Stacy Welding, followed by Dick Montague. Stacy first, and then you're after Stacy. Okay. Just so you have a warning.
I'll be quick.
This is very hard, and I'm very uncomfortable in this seat up here.
My name is Stacy Welding. I live at 1925 Spruce Avenue. I'm kind of new to this whole debate, I guess, or information. My question after your presentation, whatever it was, how much will enforcement and inspections cost Longmont, and will it cost Longmont? And how would Longmont get enforcement authority, since there isn't really a precedent for it, from what I understand? Setting aside all of the health issues of fracturing fluids in our water table and in our water supply, what are the economic impacts to our community, short-term and long-term? That was it.
Thank you, Stacy.
And I do feel like it's kind of a foregone conclusion when I'm reading this, that basically the precedence is that everything is preemptive. The state can do what it wants, and so what do? We're just going to allow it to happen. So I want to know, what is City Council's stance? Like, what is your plan?
Thank you, Stacy. Dick Montague, followed by David Pelster.
Thank you. I am Dick Montague, and I live at 1601 Great Western Drive, Unit F2. That's down in the Mill Village area in southeast. I don't believe there's any fracking planned for down there, but this is my first introduction to speaking to the fracking issue. I just finally decided I should do it because I came up with an idea that I'd like to present. While I am an environmentalist, I'm here not to present so much a partisan point of view as to a potential compromise that might be workable. And I'd like you to think about that. I believe there are two obstacles to reaching agreement on the fracking issue. One of them is that there's a wide difference of opinion as to the risk involved. And, of course, most of the people who have an opinion aren't really experts, and it's hard to know who is, and it's hard to know who to trust as to whether they're speaking their true beliefs or not. The other, however, is that there are two different groups. One stands to gain from fracking because they plan to sell the gas. Another stands to lose because they are exposed to the risk. This is especially true in water issues, where it's a rather localized group. It's more generalized risk for the air issues. But I would like to present what might be a way out of this problem. And that is for council to require, and again, I'm not going to address what is preempted or not. I don't know. Maybe there are ways around it. That any company that wants to get involved in fracking, obtain an insurance policy that will accept liability, unlimited liability for all damages caused to anyone by fracking, either in perpetuity or for as many years or generations as it takes so that it can't last any longer. Now, some might think that this is unrealistic. You can't get an insurance company to agree to this. But this is what we're asking those who are subject to the damages to accept. And if the insurance companies won't accept it, then why should we expect somebody to accept it who is not receiving premium payments every month, who does not get a share of the profits from selling gas? Now, there are a couple of advantages here. One, insurance companies are experts at assessing risk. That's their whole business. And they know who to contact to get the details. They can talk to experts, and they can form their own judgment as to whether this person is biased or not. And the reason we can trust them is because...
Wrap up your comments. That would be appreciated.
Oh, I'm sorry.
Yes,
They have a self-interest in being accurate as to the assessment.
Thank you, Dick.
Also, okay, that's it. I would just suggest that involving insurance companies to settle that matter is a good solution.
Thank you very much.
Mm-hmm.
David Pelster, followed by Joe Bassman.
Good evening. My name is David Pelster. I live at 1574 Goshawk Drive. I live at approximately 800, 900 feet from the proposed top consolidated drilling pad that's going to be next to Trail Ridge Middle School, which will also be approximately 500 feet from the Trail Ridge Middle School. And my particular concern is air quality. A lot of people that are talking about fracking mostly are talking about groundwater issues, but my concern mostly is air quality. And the reason why I'm concerned about air quality is that it's a consolidated pad. There's multiple wells, not even clear how many wells they're going to put in the consolidated pad, but it's going to be at least 5. And each well, for the life of the well, will release volatile organic compounds, which are carcinogens. I have 3 young children. We're going to be breathing these unless there's regulation on air quality. And one of the 2 things can be done. One is the closed loop system. Don't allow open pit next to my house. Nobody wants an open pit next to their house. Raise your hand if you want an open pit next to your house. I don't want an open pit next to my house. They put toxic chemicals in the pits. The second thing is the COGCC does not regulate air quality. It's not in their jurisdiction. So there's nothing the COGCC can preempt to do that. I believe it's the State Air Quality Control Commission. So I would urge that you recommend to our council and city staff to look into that, to require the oil and gas industry, in this case would be top, to pay for monitoring air quality. I think they owe it to us, actually. And then the next thing I wanted to talk about is a moratorium. The moratorium, think about who the moratorium benefits. It benefits us. And it doesn't benefit the oil and gas industry, but it's also not a ban. So what does 2 months, asking city council to extend the moratorium by 2 months, what does it do to the oil and gas industry, and what does it do for us? The entire reason why the moratorium is has even been allowed is that it allows local governments to create regulation to protect their citizens. So 2 reasons to extend the moratorium. The first is some of these issues are in our state legislature. Let them have time to work these out. Protect us until they're worked out. The second reason is the fracking fluid disclosure isn't enforced until April 1st. So when we find out what's in this stuff, we might want some time to react. That's it.
Thank you, David. Joe Bassman, followed by Dan Ditzler.
Thank you, members of the advisory boards. I'm Joe Bassman, 3414 Lakeview Circle, where I'm the owner of the surface rights. And David just helped me. I would like to speak to you about the moratorium. Dave gave a couple of reasons to extend it. I have 30. So hang on to your hats. I haven't rehearsed this, but I'm going to go as far as I can in 1 minute. Matt Jones's bill, Alex's map of where wells can be placed hasn't been studied. Who owns the mineral rights in the city? The public and the boards have not yet seen the regulations. We need to respond, cooperate. We need loop-back systems. Fast-track preempts the public input. 4 months benefits the oil companies. Help Chris Porzacek, who doesn't want to be living there when drilling starts and he wants to sell his house. Rodney Herring himself said they want to drill before there are more stringent regulations. The EPA studies are coming out in 2004. Proper research of old and abandoned wells, for example, Spring Valley. Distance in wells is 1,000 feet. Predominant distance in Weld County is 1,000 feet. New technology versus antiquated case law. Case law hasn't tested the new technology. We need to investigate the consequence of denying well pads. We need to take an honest look at water use, and I've probably used my 2 minutes. I've gotten halfway through the list. The point is this. I don't expect you to understand any of that. You had some really good questions tonight that required some follow-up. What we need is a moratorium. I just put these things together while I was sitting in the audience. We need time to consider the impact of this on our city, what we can do about it, all of the ramifications, and we haven't even begun to peel away the questions. Please push the edge tonight. No matter what options you're given, take the initiative, give the message to the city council. Tell them, extend the moratorium. Show them that we care. Thank you.
Thank you, Joe. Dan Ditzler, followed by Bob Norris.
Hello, Dan Ditzler, 1541 Chucker Drive. Start off by saying I sat on the Art Public Places Commission for 9 years, and I want to commend you all for volunteering with the city, and thank you for your time. A few things that came up during the regulations that were brought up, and I don't know that some of these have been asked on specific boards, but where's the water coming from? At one point, we asked that to City Council, and the answer was, we don't know. So the question is, where's it coming from? How does it affect our water prices overall as a city? How does it affect the major industries in our town that use water? For instance, our breweries, which is a great draw for our visitors to Longmont, which is something that we're trying to push. Another thing that I was want to encourage the setback of 1,000 feet. I understand that is something that's preempted, but I also want to encourage adding that as something that has a variance that says if you don't want to do it the 1,000 setback, you think it affects your business to do so, to do business, that you can apply for a special permit to in a public hearing to move closer to the thing, which public outcry would hopefully keep that from happening. Planning and zoning in the heavy industrial areas, I would strongly encourage to push that as far to the extreme limits as possible. I think that is a great place to start to get these where we want them, out in the industrial areas and not next to our homes and schools. Sorry, I've got scratches all over the place. There's a case where the city claimed eminent domain over a few of the wells and the mineral rights up in Spring Valley estates. I would encourage them to do so as well by the schools next to the parks and open spaces that they're currently looking at, especially Union Reservoir, Sandstone Ranch, where they're looking to put in a pad site that's equivalent to 1.4 acres in size next to the ball fields there, which I would think would fall underneath the outdoor use thing, but for some reason it doesn't. Sensitive, I don't know who's more sensitive than children going to school and having to put up with the sounds, the toxins that are going to be there, and that sort of thing. So I would think that would fall under a sensitive ruling there too. And then lastly, if painting is one of the requirements we can do, maybe we can get them to paint the big containers with murals to show what it looked like before they put their containers there. So thank you for your time.
Thank you, Dan. Bob Norris, followed by Jim Manzanares.
Bob Norris, 532 Ryder Ridge, and former chair of the Environmental Board, I should say the improved Environmental Board over the last 2 years. I like that idea of painting, but I think the Native Americans might like us to paint it before we came. So some kind of historic perspective. Anyway, in terms of truth in advertising, mentioned at City Council, there's two 1982 U.S. patents on hydrofracking that have my name on it. I did a lot of research at that time with Halliburton, and I've done work with most of the major oil companies as an environmental consultant. God bless the industry, because without the accidents that couldn't possibly happen, I wouldn't have had a 30-year career cleaning up oil and gas in the environment. So accidents will happen, no matter how careful we are. I was glad to hear somebody mention air pollution, because this occurred to me that some time ago I saw in the newspaper, which maybe isn't the best place to get information, that some of our smog and unattainment that we have here in the Denver area has been due to oil and gas activities. I also know that there will be pollution, not just the methane's not very toxic, but it does contribute to smog. But there are a lot of chemicals in there that we will be breathing, particularly people that are downwind. I'm also considered water pollution. That may not happen in every case, but those of us that worked cleaning up soils and groundwater knew we had rules from EPA in the state that we had to know what the toxicity was of everything that we put in the ground, and we had to be able to estimate the exposure, because the risk is really the product of the toxicity of the particular compound and your exposure. And when you don't know what the compounds are, you can't calculate that. So we really don't know what the risk is, and there's probably a lot of compounds they're using, chemicals, that the toxicity studies have not been done. And finding out at the last minute after you've been exposed is far too late. So I have a real issue with the way we're doing this, even if they tell us what the chemicals are, they need to be required to tell us what the toxicity of those compounds are. Thank you.
Thank you, Bob. Jim Manzanares, followed by Barbara Fernandez.
Hi, Jim Manzanares, 2005 Calaveras Court, and I live in the golf course community over at U Creek, Spring Valley Golf Estates, and it's a really nice community. We have really nice houses, nice people, a lot of kids, 2 great parks. Who can say that? And now we've got 3 pits that are right around us, 2 of us right in our subdivision. 2 of them. Just, we didn't know anything about it. No one told us about it, and we bought them. So, but we've got them now. So what's going to happen with that? I don't know. I had a question as to who owned them, and I asked that at the open house. Couldn't get an answer. Does the city own them? And no one seemed to know. If you don't know, how can you write a regulation if you don't know who owns them? I think I was told I could go look it up. I guess I can. But you're writing the regulations, so someone should know who owns those. There's high density there. We've got 144 homes just in our subdivision. There's one across the golf course. I don't know how many they have, but I'm sure it's pretty equal. So they've got the same problem we've got. So when you look at that, those 3 pits, there's 3 pits and 3 wells there. Are they active? Are they going to be active? Are they going to use them? Who knows? I'd like to know who owns them so that we can figure out if we have any kind of way to deal with it. Do you have any power? If you don't own them, you probably don't. But I think you should know. If you don't, then I think it's a shame. One of the things that's come up that I'm sure people in my neighborhood will say, property values were affected the day that thing hit the newspaper. Has anybody thought about that? Try to sell a house now if your house is over a pit. Think about that. I mean, I'm just trying to speak from the people in my neighborhood. I'm also concerned about environmental things, but I know when I go back there, there's a lot of things they're going to ask about. I would like to have a little more time if you could do it a little bit longer moratorium. I don't know what the number is, but I'd like to go back to my homeowners association so we can get a hold of our city council member and have him come talk to us so we can discuss these things. I just want to have a little more time. Whatever you guys come up with is any extension would be nice. And I have a question. I still haven't found out how we're profiting from this. How is Longmont profiting from this? I'm not. I saw a TV show the other day where they had these farmers whose water was being set on fire, but they didn't care because they were making millions. Well, you know what? They're going to drill probably under my house somewhere over there, and I'm not going to get anything except I'm going to sell my house for a lot less money probably. Has anybody even thought about that? I'm sure that somebody has. And I would ask you to all think about how this affects us, not just on, and there's a lot of people who are talking about world events and how this is, but on a local event. I always tell my kids, you can't save the world. You can only save a little piece of it. If you save your piece, you help other people save theirs. And for our little area over there, I would like to see if you guys can put a moratorium so you have more time to think about what regulations you want to put in there, or you can, and you have our support. Thank you.
Thank you, Jim. Barbara Fernandez, followed by Shelley Bassman.
Thank you very much for giving us this opportunity to speak, and I really enjoyed the open house tonight. It was really wonderful to have that opportunity as well. I think during the open house, most people seem to be very concerned about setbacks, and yet we keep on being told over and over again that we're preempted. I'd like to commend Representative Matt Jones for trying to carry legislation on this. I guess I'm pretty pessimistic that it'll get passed because you have the Speaker of the House who is very much against local control. So the suggestion that I have several suggestions for you, would be that we really push to say the drilling should only be in a zoning district that's industrial. I mean, I think throughout all the meetings I've attended, everyone keeps on saying that these activities are industrial activities and do not belong in residential areas. I think as a home rule city, you have control over your zoning, and I think to say drilling should only be in an industrial use area would be an interesting challenge and could be possibly a court case, but I think we probably would have strong defense. With that, I believe that we should, I guess, go to the mat, like people have said, and determine that we probably are going to have to defend this in court. I think the Attorney General's office is trying to intimidate cities, and I think you need to realize that There are many different attorneys in the Attorney General's office. The Oil and Gas Commission has an attorney. The Colorado Department of Public Health has an attorney. Wildlife does. And I could tell you, by being a state employee of a state agency for many years, none of those attorneys are going to agree. If you take something, if they challenge you in your court, you may very find that some of these other state agencies are going to back you in court on these issues. So I don't think we should be intimidated, and we should go forward. And with that, what my suggestion would be, if you're going to go forward, I think with Boulder County now having a moratorium, it behooves us, I think, to kind of slow down, see if we could recommend to our city council to extend the moratorium, see what the Boulder County regs would be. Then if you're going to be challenged in court, how wonderful it would be to have a friend in court. This way it would be like Boulder County and the City of Longmont. Those are my suggestions, and thank you very much.
Thank you, Barbara. Shelley Bassman, followed by Kay Fissinger.
Shelley Bassman at 3414 Lakeview Circle. First, thank you for your volunteering for the city. It's, we all need to pitch in however way we can. I'm deeply sobered. I went down to the Capitol today to testify for, I didn't know what it was called, testifying, but for 1,000-foot setbacks and closed loop completions. No-brainers to my way of thinking. The industry has the capacity to drill laterally in Weld County, Anadarko, and Encana. The average lateral drill is 4,000 feet. To tell me that they can't accommodate a 1,000-foot setback makes no sense to me. And 1,000 feet is what has been, anybody who's thought about it, that's the least safe. I know in Flower Mound, Texas, where they have 1,000 foot, and we're looking at 1,500 feet this summer, but they have 1,000. And they did a study about property values, and they drop precipitously the closer you are to the well, duh. And at 1,000 feet, generally, they're back to the neighborhood. And as I say, the industry can accommodate this. It might cost them a little more, but a $28 billion industry can figure out how to make citizens safe. And then the other bill that was is the closed loop. Why anyone would want pits belching benzene into our atmosphere, benzene and methane and all the rest, all those poisons into our atmosphere. And people on the western slope are sick with those miles and miles and miles of open pits going down the Colorado River. So the new technology is closed pit, or is it closed loop? The nasty stuff never gets to, it's enclosed and then dumped down a big deep well. But it doesn't, we are not exposed to it. And this is the new technology that matches the new technology of directional drilling and all the rest. And why the industry wants to not agree, I do not understand. And it sure looks to me like that industry has an awful lot of tentacles into the political process that preempts you and me and our kids and their kids. I ask for an extension of the moratorium. There were so many questions raised tonight. I think we need to weigh, do we want to challenge? And could we go with Boulder County and challenge this?
Thank you, Shelley.
They need being challenged. Thank you.
Thank you, Shelley. Kay Fissinger, followed by Teresa Foster.
Kay Fissinger, 2199 Creekside Drive. I know very many of you. As a former chair of the Board of Environmental Affairs, I've served with some of you, and on PRAB and Water Board, you have heard me speak before many times at public invited to be heard. Glad to see you all again. The content of the packet that you've all received and that's on the city's website I found immensely disturbing. In fact, there are probably some words that even go on beyond immensely disturbing. The COGC table included with the Director David Neslin's letter to Douglas County was intended to intimidate the county, and it did. That letter was written on December 15th. To be sure that the industry position was heard loud and clear, Attorney General John Suthers wrote to Arapahoe County on December 28th and to El Paso County on January 10th. And once again, the intimidation worked. Clearly, we have certain parties circling the wagon to assure that the oil and gas industry has substantially carte blanche. You might ask why I use charged language. Look up the background of Governor Hickenlooper's appointments to the COGCC. There is little, in fact, almost no representation from outside the industry. And I might add, and I'm not sure if anybody has noticed this, that the shorthand for the COGCC is the Oil and Gas Commission. I think it's very telling that the word conservation is rarely used when referencing that commission. Did you know that Director Neslin just resigned his position to take a position with a law firm that represents Encana Oil? One might ask how many other companies that law firm, oil companies that law firm will represent. It's no stretch in my estimation to say that the COGCC, especially in its current configuration, is nothing more than an industry shill. And that accounts for all of the thou shalt nots that show up in this packet. Lastly, I'm concerned that one of the most significant aspects of the SG Interest versus Gunnison County ruling on January 3rd was omitted from the case summary, although it was discussed somewhat during your Q&A. The judge cited previous case law and legislation to support a ruling that preemption by the COGCC was automatic in only a limited number of circumstances, and that most local regulations would be subject to evidentiary hearings, requiring the operator to prove material impairment and damage. The MOU in there, I notice, is unsigned. I don't know if that's significant or not. If it's a draft and it's not signed yet, that does cast it in a different light. It is my hope that Longmont will not cow to intimidation, regardless of its source, and will put the health, safety, and well-being of the community first and foremost. Thank you.
Thank you, Kay. Teresa Foster, followed by Angie Layton.
Good evening. My name is Teresa Foster, 712 Thornwood Way. I hope you're all having a good evening tonight. I thank you all for being here and weighing in on this very important decision. I wanted to ask you what your quality of life, clean air, clean water, and so forth mean to you. You know, as a resident of Longmont, those things mean a lot to me, and I think to everyone in this room, and of course everybody out there who might be watching this tonight. I did want to say a little bit more about the Spring Valley Estates and the historic wells that are found beneath that neighborhood, as well as the open pits. There is a case in Florence, Colorado, where when they had done fracking near historic wells, there had been actually activation in the historic wells. And so what happened was explosive levels of methane were found in homes that were above these wells. And so that makes me feel very concerned for people who live in that part of town where they could actually become harmed if there was fracking done out by Union Reservoir, which is only a couple miles away. And I had a chance tonight, actually, after speaking to the PTO over at the Trail Ridge Middle School, of taking a drive down by Rod Brewski's home, who lives off of County Line Road number 1, just south of County Road 20 and a half and north of Oxford. And I would really highly recommend that if you guys really want to see fracking in action, you go down and take a look and see what it looks like. There's a huge drill rig right there, and they've actually blocked it off so you can't really see the action of going on at the pad. But I was out there a few weeks ago before that block was there, and I recorded it, and I have a YouTube video, actually, if anybody's interested. And you can actually hear the noise, and I'm not really sure, how people would feel if there's something like that was going on 350 feet from their homes, or even less. So I don't really believe the COGCC is out to protect us at all. I think they're really, really out there for the oil and gas interests and not for the citizens' rights. So thank you.
Thank you, Teresa. Angie Layton, followed by Matt Jones.
Thank you for the opportunity to speak with you this evening. My name is Angie Layton. I live at 619 West Juniper Court, and it's in Louisville. I'm here tonight because I do care about this issue, and I was involved in the Union Reservoir preservation several years ago, where there was some real concerns about what happened in Longmont. And again, I think that this is an issue where the outside of Longmont has a lot of pressures on it, and I think that it is very important that as a commission and recommendations to City Council that you do make intentional decisions based on what is the best for your community in the long term and not short-term profits or goals, because whatever natural resources Longmont may have, they're not going to go away. But if we make very hasty decisions that threaten the quality of life, and certainly Teresa and I did take a trip down to see the oil rig this evening and along that bumpy road that has basically been destroyed, that there is a real threat to the quality of life here in Longmont, that a lot of the people who are living down there in a very beautiful outside rural area of Longmont, and many of those people's homes will have some significant degradation of their environment, even if there isn't a single health risk that they can prove, but just having that very large oil rig on the other side of the road will certainly have an effect on their quality of life. And certainly with Trail Ridge, that will also have some sort of an effect on the students there. And so I hope that as a group, you are very careful and very intentional in the things that you are doing going forward, so that looking back 5 years from now, you don't say, oh, darn, I wish we hadn't done that. So thank you very much.
Thank you, Angie. Matt Jones?
Thanks for letting me speak. My name is Matt Jones. I represent South Longmont, Louisville, and Lafayette in the State House. And in addition to representing 74,000 souls in the area, I also see my role as being a liaison to the cities I help represent. And that's why I'm here today. I want to say, first of all, I think it's good that we have jobs from oil and gas. It's good that we have a domestic energy source from that. I just think we need to do it responsibly, and that's my bottom line. We need to protect kids and children. We need to make sure local governments have a real voice in this process. So I'm going to talk about three things tonight. The first two have to do with the state, and the last has to do with the decision you're going to have to make, and the council is going to have to make. But first of all, my bill will be read across the desk, in other words, formally introduced either tomorrow or might have been late today. It does two things. It does reinforces the Land Use Act and says oil and gas is permitted under the Land Use Act. The second thing it does, it says that like other minerals, aggregate, coal, local governments permit them. And that's what the bill does. But I got to say, this afternoon at the Capitol, where I just came from, the local government committee heard the 1,000-foot setback bill, which they killed 8-3. And then they heard the setback bill, which lost by a similar vote. And so I'm going to do my utmost to pass the bill I'm sponsoring. I was the co-sponsor on this 1,000-foot setback. But it's an uphill battle. We even had a skirmish over providing more inspectors, 5 more people to help with that, because some people thought that industry shouldn't be paying even though they wanted these inspectors. So that's the environment the State House is in. Second of all, the COGCC, Colorado Oil and Gas Conservation Commission. I would not hold my breath and wait for relief from that entity. All you got to do is look at the Ryder well, which is near Trail Ridge Middle School. It's been there, 30 years, I understand. 2006, they found that the developer found that there's a problem. Took them a year to do something, then they put it off a year, and it's just dragged on, and it still has levels of benzene far above state standards. And the other thing I might say is that it's great they're starting the setback discussion, but that 2007 legislation you talked about took several years to get going, and it was a big battle. So those are the first two state things. Probably no legislative help. Probably no Oil and Gas Commission help. And is that my red light? Oh boy. And your wells are imminent to be drilled. And once they're in, they're in. You're done. So what I would say to you is seize the day. Do everything you can to control this issue yourself. The memo that's attached to your packet, which I read, and it was a good packet, I thought, from the Attorney General, I'm told, overstates the case and makes things pretty black and white when they aren't. And that, for instance, the Voss decision in Greeley said it didn't preempt. It said you can't stop drilling, but it didn't say you can't do something else. It left that question open. So those are the kinds of things, those gray areas that I would suggest you look forward and look to press your case and do the most you can about this for your local citizens.
Thank you, Representative Jones.
Thank you.
Okay, board and commission members, we're going to take a 5-minute break so you can stretch your legs and get some coffee and that sort of stuff. We're going to test out the voting systems. When we come back, we'll take a roll call vote and ask you a series of questions so that you can provide some feedback to the City Council. All right, little break. Commission members, please come back and have a seat. All board and commission members are up here. Yep, there we go. Yep. Do all the monitors have a signal? Is there anyone that doesn't have a signal on your monitor? It just may be easier to read the questions that way than trying to read around to that. Okay. Should do a roll call. Are you okay? Okay. Thank you to the board and commission members. And I will appreciate it if everyone else can take their other conversations outside where we have cookies or coffee. I guess just coffee. I think we ran out of cookies. I think they were still nuts. I have nothing to say about that. Okay, so so we are back for oil and gas conversation with our boards and commissions. And so what we're going to do is we're going to spend some time with the option powers set. But first, before we do that, we want to make sure that we have a formal roll call vote. So Jane, would you do a roll call vote for each of the boards present?
I'm going to start with the Board of Environmental Affairs. Joel Danforth.
Here.
Desiree Holtz. Elizabeth Hennessy. Sue Liu.
Yeah.
David Neufeld.
Here.
Douglas Ward.
Yes.
Rich Yale. Water Board members, John Bruning. Darcy Juday. John Caldwell. David Swenson. Parks and Recreation Advisory Board, Rick Accountis. Greg Braun. Kelly Dirks. Doug Gallagher. Matthew Linden.
Here.
Sharon O'Leary. Jim Wardell.
Okay, great. Thanks, Jane. Okay, so everyone on their desks should have one of these keypads. If you don't have one, let me know. Okay. And so for those of you who are backs to the screens, that's why you can turn on your monitors. You can see the questions over the monitors as well. And of course, you that are sitting there hopefully can see them on the monitors. I'll also read them a couple times. The way that these work is that if we ask a question that has one answer, you just push the button of that answer for you, so that number, and it gets recorded. If it has multiple answers, so we may say, what are your top 3 concerns? You hit your top 3 concerns, maybe that's 1, 4, and 5, and then you hit send. And that's basically how these keypads work. They work very easily. You'll be able to see your answer on the screen, and you'll have a certain amount of time before we say, okay, that's it, to get your votes in, and we'll be able to see who's straggling out there as well. So my thanks to Kim for putting this together. I do want to just reiterate a couple things. First of all, the council is the decision maker in this situation as far as they can. You've heard a lot about preemption and about the whole state regulations and what's happening in the legislature. But at the same time, what you're going to see is you're going to see some questions that really talk about that risk. So in areas that we talk about, you're going to see some things that actually Eugene and I have been calling red areas, areas that have shown preemption, that have some sort of case law that showed preemption and that the city is likely preempted from making a decision on. When we ask you how you support city action on those things, we want you to weigh the fact that there is a risk to it, that there is a risk of litigation, but we wouldn't be asking the question if we weren't serious about finding out your answers around, is it worth that risk of litigation? There are other areas that are uncertain. Those are kind of orangey areas where there's no case law and it's not particularly set that, hey, yes, this is preempted, and we'll be talking about those as well. So just so you can get kind of the language for what we're talking about. But first, let's try out using the keypads. Does anyone have any question on your role today, where we are in this conversation, what you're looking for? Okay, at the end, we'll have an opportunity to ask some additional staff questions. But for the most part, what you're going to see is questions that are similar to the ones that the public was asked. Also, you should have the copy of the public answers, and my copier broke as we were making them, so for members of the audience, we'll be posting it on the web as well. So I recognize we didn't have enough copies to get everybody in the audience, but we'll be posting it on the web. Broke, out of tone, or something that I don't know how to fix. So, okay, any questions from the boards and commission members? Okay. Well, on what we're doing at this point. Okay, so the oil and gas survey, we have feedback from the boards that will be considered and presented to the city council. So not only do we have the public piece, And all of your dots would be counted to give to the council. We also have the half-page comment cards, and then this is a way that we can aggregate your all's opinion on your boards. So first, let's talk about how to become familiar with the keypads. Hit it, Kim. Here's the first pressing question. What are your 2 favorite colors? Let's make sure that these all work. So, for example, if your 2 favorite colors, mine personally are black and blue, you would put 1 and 2 and then send. So go ahead and try it out. Put your 2 favorite colors and send. At the bottom, you'll see we have 30 keypads. How many do we have actually active? 14. So as soon as we see at the bottom there that we have 14 folks, 1 more person who can't decide. Okay, I'd say go ahead and hit it.
Can everybody hit them, do it again?
Just to make sure, because we have
Remember,
1 person that doesn't have a keypad that's
we want to make sure all the keypads work. So hit 2 numbers and then hit send.
14. Okay. There we go. All right, very good. Okay, they're all working. Okay, so then Kim's going to actually be able to show you the answers right away. So she's going to force that, and the number, so people like blue and green. Those are the city's colors. Good job. Okay. So this one is going to help us to aggregate what boards are voting on what. So when we give this information to the council, we'll be able to say that the Board of Environmental Affairs felt this way versus Parks and Rec Advisory Board felt this way. And we'll be able to give a total of the entire group. So what advisory board are you a member of? Do not hit send, just 1, 2, or 3. Okay. It's a nice mix. Very good. Okay, the next question. Now there's a series of 3 questions here. There are several issues that we want to talk about. We've kind of mixed them up into 3 slides to get relative importance. So you're going to see some duplication on the 3 slides to just try to get what relative importance is compared to other things. So on this one, please choose the 3 most important oil and gas issues as they relate to the development of the regulations by the city. So you can see 1 through 8 there. If you need me to read them out loud, let me know. So type your 3 numbers and then hit send. One more. Okay. Okay, so from this group, enforcement was the number 1 and most important issue, followed by inspections, and then setbacks. It seems to mirror pretty similar to what I saw in the public comments as well. So this is a different mix-up. Some of those are the same, like consolidation of wells is the same, but green fracking fluids may be different. So take a look at this list and decide the 3 most important oil and gas issues. This helps to give us some kind of placement around all of the issues that surround this. Let me know if you need me to read them. One more. There you go. Okay, under this group, the closed loop pitless system seems to be way out there, 93%. Followed by the monitoring for water and air quality and the use of green fracking fluids. Thank you. 1 more of these where things are kind of mixed up, just to make sure we get a relative importance. Last one of this type for this section. Again, closed loop pitless systems followed by monitoring and use of green fracking fluids. Okay, great. Thank you. That really helps us to kind of get the relative importance of the enforcement piece in there. So knowing that current COGCC regulations likely preempt the city from requiring the consolidation of wells. So let me kind of give you a preface for this question. So these are the things that that Eugene and I have been calling red. So these are the things that there's case law and there's people saying, you know, AGs and all those other folks, that we are likely preempted in these categories: the consolidation of wells and associated facilities, larger setbacks, mitigation of site noise and visual impacts, and financial assurances. And we would not be asking the question if the council wasn't considering these kinds of regulations, but there is a risk to it because it shows that there's a history showing preemption. But at the same time, we're asking the question and we're asking your feedback because the council may indeed decide that that's worth the risk to push that litigation. So knowing that these are red areas, likely preemption, at what level do you support the city in requiring these items? Knowing there's a risk and a litigative risk, weighing those benefits, what level do you support? So knowing that the current COGCC regulations likely preempt the city from requiring the consolidation of wells and associated facilities, larger setbacks, mitigation of site noise and visual impacts, and financial assurances, at what level do you support the city in requiring these items? John?
I guess I don't understand the question. Understand the city supporting the existing COG regulation or going farther than that?
Going farther.
So why didn't it say that?
So what level do you support the city requiring things around these items? What level do you support the city pushing back against and creating regulations in these areas that show they're likely preempted? Does that help?
Not really.
If I reword the question to what is your level of risk in this case? So how strongly do you feel that the city should push these regulations despite the risk?
Beyond what they are now.
Beyond what they are now.
So that, just say like that.
Beyond what they are now.
Okay. Thank you.
It would be interesting to know, so I don't recall in the staff presentation any sort of discussion on, you know, you looking at additional costs for the city. How do we judge the risk here?
That was my concern. I said I was very prepared with the packet, but then hearing the public input, it raised a whole new series of questions in regard to litigation and risk, and I wanted an opportunity to have some of that addressed before we got here, and it was decided that we would go through this first and then talk about it afterwards.
Eugene, is that something that you could come in and give a little more information about?
So, specific question?
What is, you know, being a self-insured city, does that play into the city's willingness to take litigation risks for its citizens?
So that's a question that would need to be answered by council. Just to give some sort of context, what we're saying is there is binding appellate case law, which a district court or a trial court level court would be required to follow should the city be sued if we were to say pursue regulations greater than the COGCC in some of these areas. And you know, whether or not you're self-insured, it's still taxpayer money that is going to fund the defense of this litigation. Whether or not we do get sued, hard to tell. You know, I've seen a lot of other jurisdictions adopt larger setbacks in the COGCC, as far as I know, after the town of Frederick case, and those had not been challenged. So it's a crapshoot, certainly. And the COGCC, through the Attorney General, is coming out with these nasty grams to all these local jurisdictions saying you're preempted, don't do it. And for the most part, the jurisdictions have backed down. We have not seen a jurisdiction come out aggressively and adopt those regulations and see what the AG is going to do. they certainly would be able to bring suit to assert their preemption authority. So, I don't know what more beyond that. I mean, it's a risk that's out there, and it's real and substantial, and it's in face of binding appellate case law.
I think that's helpful, Eugene. John?
To understand the categories the city is using, is that the red, and you prefaced by saying these are the red areas. Does that also mean that there's substantial case law involving these red areas? What other color areas are we going to have tonight?
Orange is the other one. Ones that there is no
Does that also mean
case
there's
law.
there either isn't regulation or there is not defined case law?
That's absolutely correct.
Go ahead.
Yeah, I'd just like to ask, obviously we'd have to pay for attorneys to litigate this, but are there punitive damages that might be are levied against the city? Are there any sort of, fines that we would have to pay if we lost? Or is it a cease and desist? We can't enforce our own ordinance.
I think that it would be primarily invalidating the regulation. To find punitive damages against the government legislating in good faith, I think would be pretty remote. And obviously there's no property damage or anything like that. It's just regulation.
And Kim, even though we're at 14, don't hit it. Don't hit it yet, because you have an opportunity as we're having this conversation. You can actually change your vote until she hits that button. So you're welcome to change your vote while we're having the conversation. Doug?
The only point I guess I would make,
Can we mic Doug? Joe, can you turn that on? At least kind of get him near that thing. It's the only way the public can hear you.
maybe they
at
don't
home.
want to.
The public at home can hear you. They can probably hear you.
The term, I guess I'm a little bit in the camp with John, the term support. I mean, there's some actions I could envision the city council taking to attempt to arrive at some agreements beyond, rather than just, throwing down an ordinance and then waiting to go to litigation. So in terms of supporting, I'd be in favor of supporting, trying to do something. I'm not sure I'd be in support of just trying to get into a legislative trap or litigation, I guess.
Well, I was in the working group that formulated these questions, and I think our intent was direct regulatory approach here.
And later on, you'll be asked around questions around if there's an opportunity to do a memorandum of understanding, then would you be supportive of that type of thing? If that helps with this answer. This question is really around regulation.
So the city of Frederick, in sending a letter and questioning the Oil and Gas Commission, obviously then some money has been invested in just posing that to the commission.
So the town of Frederick was an actual case,
Right.
appellate case law. And so they passed a regulation. They were sued by Narco, an operator. I can't remember if the state joined that or not. And so, I mean, there was the cost of litigation. And to get to the appellate case level, $50,000 to $100,000 minimum.
Okay, that's good information.
Yeah, that's helpful. Okay, so feel free to change your vote. Everyone seems to be in. I'll give you just another second. Okay, show those results, Kim. Okay, so 50% strongly support. Yeah, I couldn't catch that there. Can you go back one more? Yeah, there you go. So 50% strongly support, 36% support, 0% were neutral, 14% opposed, and 0 strongly opposed. Okay. So this is so knowing that the COGCC regulations likely preempt the city from requiring setbacks greater than those required by the COGCC, what area do you believe is most important to have a larger setback? So when you're taking a look at these things, if there was an area that the city was to create some additional setback regulations at the risk that we've already talked about, What is the most important area that you believe should have a larger setback?
So we're restricted to one.
In this case, restricted to one. Yes. We recognize, and the public vote certainly was all, and I would say that's probably a fair piece. But and again, we're just trying to get relative priority for the council to consider. Okay. Kim, go ahead. So residences being the highest. Yeah, residences, schools, and then water bodies. Okay, so the next one is talking about the length. So knowing that the current COGCCs, again, likely preempt the city from requiring setbacks greater than those required, what recommended distance setback should the city consider? So if the council is going to push this envelope, what distance? And let me tell you, 150 feet is the general COGCC regulation. 350 feet, think of the size of a football field. Football thing. I know, Super Bowl was just Sunday. I know. 500 feet, a football field and a half. 1,000 feet, 3 football fields, and half a mile is 3 times that. So when you're thinking about the setbacks, what would you recommend as the distance the council would pursue?
Just point out that 350 feet is for the high density.
350 feet for the high density. Thank you. I appreciate that. One more. There you go. Okay, so most people said 1,000 feet, 43%. 36% said 500 feet. 14% said 350 feet. Oop, and 7% said half mile. Sorry, I should have started there. Thank you. Okay, so this next area is the orange area. Although it is uncertain whether requiring closed loop or pitless drilling systems, the use of green fluids during drilling and completion, wildlife and protection plans, and water and air quality monitor is preempted. To what level do you support the city in regulating these items? So these are the orange items that do not have case law, that is uncertain whether that is preempted or not. So there is a risk of liability, but it's different than the other area. So what level would you support pushing the envelope in these areas? Or however you said it, John. One more. Feel free to vote again, just to make sure we got everybody. There we go. Strongly support. So much more supportive in an area of less risk. 71% strongly support, 14% support, 7% neutral, 4% oppose, and nobody strongly oppose. Okay. So the next one. Do you support the city in negotiating an MOU, a Memorandum of Understanding, with the COGCC to allow cooperation between the state and the city in areas that are likely preempted? So we asked you your support around just flat out doing regulations over what's there. This is what is your appetite for trying to negotiate with the state to create an MOU to hit some of those red areas, likely preempted. Very strong support. 86% strongly support, 7% support, 0% neutral, 4% oppose, 5% strongly oppose. Okay. So if the city were to do an MOU, do you support a Memorandum of Understanding? Do you support the city in seeking inspection authority over oil and gas operations, even if the city doesn't have enforcement powers? So currently there's no enforcement powers. Would you still support the city doing inspection? We're going to ask a series of these questions, too, around how much do you support? What would you be willing to do to support inspection? Okay. Yes. Strongly support, over 70%, and then support, neutral, and oppose. Okay, so obviously the city would try to have operators pay for those inspection fees, but if the city cannot require the operators to pay for monitoring of water and air quality and those inspections, do you support the city funding these activities, your taxpayer dollars going towards inspection and monitoring of the wells? Doug, can you get on your microphone, please? Thanks. Sorry.
No, there's taxpayer dollars, but there's also, I presume, royalty funding coming from, or some kind of funding coming back to the city for these, right? So it wouldn't necessarily be a net reduction from city's current revenue sources, right?
That's
Is
a
that
good
correct?
question. Brian, do you know that answer by chance, or Dale? Yeah. There's not a lot coming in now. That's what I heard from Dale. Not a lot. Let's make the assumption. The question is really, do you believe that it's important enough that taxpayer money go towards it? And there's no, at this point, estimates on what those costs would be, but just how important do you think that is for the city to do that inspection?
I guess it's known who the number 4
Yeah. That's right. We still won't know what you voted. Okay. Can I split vote? Well, not too split. 36% strongly support, 50% support, 14% neutral, and nobody opposed or strongly opposed. So willing to pay some money. So do you still support the city funding, monitoring, and inspections, even if it means a cessation or reduction in other municipal services, or some sort of increase in either rates or fees, something like that? So since the costs are yet unclear, if it ended up being something that was a lot more money, how much would you support that? All right. So a little over 20% strongly support, 42% support. And then we have neutral and oppose, probably about 22%. Okay. Okay, so when you talk about notifications around these different types of things, if we could require some sort of notification, what 2 activities do you think people would most likely want to receive? Or would you most likely want to receive notification about when they occur? And you select 2 and then hit send. So drilling, completion or hydraulic fracturing, spills and remediation, or plugging and abandonment. So you hit your 2 choices and then send. Okay, so spills and remediation, top, and then drilling. Good. And how far do you think the notification should be from the well? So from the well site, do you think it should be 500 feet from the well site, 1,000 feet from the well site, half a mile, or anything within the city limits? Okay, so most people in this case said citywide within the city limits, 36%. And then kind of a split, 21% for 1,000 feet, half mile, and 1 mile. Okay, thank you. So as an incentive, so this really is talking about permitting to some extent. As an incentive, if operators agree to enhanced standards such as greater setbacks, monitoring, et cetera, do you support the city using an administrative staff level review or as opposed to a conditional use review before Planning and Zoning Commission? So if operators are saying, yes, we'll meet your regulations, are you comfortable with that going through as an administrative piece, as administrative review, or as opposed to the conditional use review before the Planning and Zoning Commission? So if you're strongly supporting the city using the administrative staff level review. One more out there. What's that? Number 14, right? It's probably always a different one. So everyone go ahead and vote one more time. Just make sure we got it. Yeah, if it's not saying okay, let us know. Okay, everyone vote one more time. Everybody hit it. There we go. Found it. Got it. Okay, support and strongly support with neutral and opposed. 15% opposed, 21% neutral. Thank you. Okay, so now that you've heard everything that we've talked about, you've heard the public, you've seen their dots, you've gone through this exercise, and we'll have a little time to ask some more questions and just have a little discussion afterwards. But now that you know all of this information, now what are the three most important issues regarding oil and gas drilling that the city should consider when developing regulations? We're only going to ask this question one time. We're not going to ask it 3 times again. What do you think are the top 3? Number 14. Make sure you need to hit your 2 numbers and then hit send. There we go. 3 numbers. 3 numbers. Don't let me shortchange you. Okay. Closed loop systems, monitoring, and then looks like green fracking fluids and inspections. Pretty close though. 29% and 36%. That's 1 vote. Very good. Okay, well, first of all, thank you in the audience for letting us get through that. Certainly appreciate that. But then for board and commission members, is there more conversation that you feel like you need to have or other things that you feel like the council should know from your perspective before we end the meeting? Sharon.
I thought a citizen raised a pretty good point about what costs potentially could be passed on to the citizens of Longmont. So maybe the use of water or things like that. So, I would just like, when we're looking at risks, what risks or potentially hidden risks are there to the citizens of Longmont as far as roads, water and things like that? What considerations have you given, and what do you see potentially, especially with the use of the high volume of water that they would use? What's the ripple effect to the citizens of Longmont?
So Brian or Don or Dale or Eugene, is there any data on that could help answer that at all? Or is that just, if the answer is no, then that's something we'll make sure that the council recognizes should be a consideration from this group.
That sounds like something right now.
It's like a Dale question. You said water, right? It sounds like a Dale question.
So the question on the issue of water, I think we have some information that's going to be coming out in the council's packet on the 14th, but the city has a water supply contract. It's a 20-year contract with one of the particular haulers. It's called A&W Water, and that is a contract that calls for delivery of, I believe, up to about 600 acre-feet of water in a given year. And that's water that is reusable effluent from the city's wastewater treatment plant that is otherwise going down the river. And what we've been able to do is enter into a contract for delivery to a well field where they actually pull the water out of the South Platte out near Kersey. So that's probably the largest contract. And again, it's a contract where they pay the city for the delivery of that water. But that's water that is not in competition with delivery of water for citizens or for irrigation of the city or parks or that kind of use. We also sell water through what's called bulk water sales through fire hydrants to any number of industries, one of which is has been oil and gas. I don't know the numbers exactly off the top of my head, but over the last several years, we have sold, I believe, somewhere around 7 million gallons through fire hydrants. I think in the most recent year, it was less 600,000 or 700,000 gallons have been sold. And just sort of in perspective, the city's average day use is about 12 million gallons a day, somewhere in that range. Could be wrong. Our peak day is around 30. I know the water board guys probably know this better than I do right now, but so I don't know if that helps. But the water we're delivering is the largest chunk of it is through that water supply contract. That again is a 20-year contract. I think we entered into it in 2008 or 7 or 8.
Are they on a sliding scale like citizens are? So after you hit X amount of gallons, you're charged a different rate, and once you exceed that, you're charged a different rate after that?
The way the rate works for that particular contract is a set rate. I believe it's $258 per acre foot, and that amount is set by the debt service and payments that we have for the most expensive water supply that the city has, which is Windy Gap. And so that's a flat number, so it's not the same as a tiered rate structure. It is, however, subject to change if the city does additional rate and fee studies, and if that change or that cost changes, then that would be reflected in future delivery contracts.
Dale, that contract with A&W technically is called an augmentation, which means the water that Longmont provides is for actually to replace a depletion from wells that they pump from versus diverting the water we're sending downstream. It's an augmentation, water augmentation thing for them.
That's correct. And then I think, Sharon, you also had a question on roads, and I believe we can address that through the regulations with regards to permitting for damages to roadways. What I don't know for sure, and I'd have to defer to the planning staff, is if that is something that we believe we're preempted on, or if we have local control over, because I would hope that we have the ability to recap or recoup any damages to city highways that might be caused. Am I wrong? Are we preempted? No. So, and we're not preempted. So.
That green area. How about that? So, I'm sorry, I think you were next, and then Rich. Or was Rich next?
I'm not sure.
Okay. We'll start.
Go ahead, Rich.
Okay, go ahead, Rich.
I had a question for Dale, and in our regulations.
Here he comes.
Sorry. In our regulations, can we require that they put a priority on one using wastewater rather than the bulk water from the fire hydrants? In other words, I want them to use the wastewater, and I also would like to see in the contract that on the recycle, the recovered water, they're using that over again in the fracture.
So if I understand the question, and let me clarify first, the contract that we have with A&W is only for untreated water. So it's not water coming out of hydrants. There's a big cost incentive to use the contract that we have for treated effluent because it's far less expensive than getting the water from a fire hydrant. And so there's the market, the cost is the biggest incentive why folks would want to go that route. With regards to our particular contract, I think we have something in our contract that they have to use best management practices in the areas of conservation, because that's been an issue for the water board for a number of years, and the staff and the city council to make sure that all the folks that we're entering into contracts with, whether it's A&W or Central Colorado Water District, that they are using their best management practices in their industry, which in the case of oil and gas, I believe most of the operators are working towards higher levels of recapture and reuse of their supplies. I don't know the exact numbers, though, but I think that's also in their interest economically to do as well.
Just stay right there in case Rick's question is for you. No.
Actually, I'm going to direct it at Eugene again. Through the course of this conversation, the underlying theme to me is risk. It's risk of this industry. It's risk of what the city does. To that point, is there any reason why the city could not or should not extend the moratorium?
You know, I mean, that's a question for council. That's a council decision. I don't know, you know, I'm here to provide legal perspective and legal advice, and council makes policy decisions on a number of factors, of which legal is just one of them.
I guess I'm looking for, does the state require us under these circumstances to come to some sort of decision in a certain time frame?
I mean, there is case law for in temporary moratoriums and land use situations. I think it was Pitkin County, where a 10-month moratorium was held to be reasonable. You get out much beyond that, you're sort of out on your own, not quite knowing if there's supporting case law for longer moratoria. And, you know, certainly the industry doesn't like moratorium. And so, you know, there's a number of factors that go into that analysis.
Based on what I've heard, then we have a little bit of leeway here then.
We would.
Thanks.
Darcy?
I'd like to reiterate John Bruning's suggestion that we pursue finding out if we can get Union Reservoir designated as a public water supply, since it is in our planning, and also to pursue having it declared an outside activity area. The answer to that question was we're not quite sure, so I'd like to see if we can find out definitely whether that's a possibility. Thanks.
Thank you. Any other questions?
This is sort of a follow-on to the moratorium question. In terms of the timeline that City Council's mapped out, where we've got a first reading middle of March and then a second reading the next week, the following week, is there any sort of precedence in terms of, you know, the first reading having a little bit more of a delay between first and second reading, so it gives you an opportunity for COG, CC to sort of look at what's proposed, and then at that point maybe work out an MOU? Or is that
probably a Eugene question?
So the schedule that we laid out is to make sure that we have an effective ordinance and regulations before the expiration of the moratorium. So there's nothing that would prevent you from having more time between first and second reading other than the expiration of the moratorium. I don't think that the MOU negotiation process for the COGCC is a quick process. So
I guess last comment is, would board members be interested in kind of motion of council to extend the moratorium another 60 days?
So this isn't a question that we asked in the option power piece, but would you mind doing a hand vote for this and just saying, would you be interested in asking the council to increase the moratorium less than 10 months but more than now, more than it is now? If so, raise your hand. Okay. Thank you. We'll make sure that we pass that information on to the council. Yeah, Doug? Sorry, I need you to use the mic.
Maybe people leave. You know, it just fundamentally bothers me about about the situation of the latitude that this industry seems to have. I mean, it seems like we have more control over where a gas station goes in town than what we do on placing our property. But on the other hand, watching through the years, the costs that the city has spent in litigation on things that we've gone after. I'm also, significantly opposed to spending hundreds of thousands of dollars, again, getting in litigation things. So, for my 2 bits, I don't want to just roll over and play dead, but I'm certainly not in the mood to go spend, taxpayer dollars to fight another fight in the courts or with attorneys at $500 an hour yelling at each other.
Okay. Yeah. Okay.
Something we haven't talked about. Something we haven't talked about. The city owns mineral rights within the city limits. The question hasn't come up. What should the council's position be on developing or not ever those mineral rights? Boulder County Open Space has taken a position on that already. It would be interesting to know. I don't know, acre-wise, it's fairly considerable, the amount of land that Longmont owns the mineral rights within the city limits. What the position would be of this community as it relates to development of those sites for mineral.
We'll pass that on to the council as well.
It would, wouldn't it, John?
John just said it depends what the regulations are.
And how much revenue?
And the revenue.
Perhaps.
So I do want to wrap this up. So kind of last comments or questions that you want to make sure that the council hears?
Yeah,
especially from those who haven't
I
spoken
had
like Joel.
Yes. One of the COGCC's recommendations is disclosure of the fluids on fracfocus.org, the website. I checked yesterday. I didn't find anything for top operating company. And I'm thinking as we address the risk issue, that's probably information that we'll want to have for any sort of risk assessment. And along similar lines, I also think that information that would be pertinent to us and our financial interests as a city would be the price fluctuations in natural gas markets, given the glut of natural gas currently on the market, may affect our ability to recover costs and address issues such as that. Doug, did you have something else?
Yeah, is
Everybody good? Rich gets the last word. Go ahead.
In looking at this whole situation, I see there's three. To me, there are three primary management tools for enforcement. One would be a performance bond, and the other would be your site inspections and the pedigree of the material. You've really got basically a closed system, and if you were actually able to know the pedigree, the chemicals going into it, and be able to do physical inspections of it, this would significantly, I think, reduce the risk that the city would be assuming. The main thing that we see here is the way the regulations are set up with the Oil and Gas Conservation Commission is that there's a primary statute that authorizes their function, but some of these case laws that are coming up that either preclude or limit what you can do with a performance bond and what you can do with inspections are all laws made by the judges that are based off the regulation. And I don't see why we couldn't ask council to put their weight behind asking the legislature to come up with an energy policy which balances. No matter how you cut it, there are two needs. There's water and there's energy, And the state fills the function of the government of balancing both those interests, the conservation interests, and because no decision or one decision is made in a vacuum on either one of these. And if they were to come up with it, I think it would be fairly simple. Hopefully they could get this through politically, but all they would have to do is set an energy policy, and the principles that set up the Conservation Committee or Commission are already there. And if that was to apply a policy clear down through any governing body in the state that's regulating, then you clear up this issue of preemption. And I see from that we would be able to collect in our fees, just like we do on building permits on residents and businesses, the cost of this. And I also see where in that we could have inspectors be sort of like the police academy. They would go through there because it's a highly specialized training, and then come back and be deputized to do the enforcement. And if we had that energy policy, we could do those things. And so I'd recommend that the boards recommend to council that we lean on the legislature for this.
Okay, so it is just at 10 o'clock. I would really like to thank the public who all came out and gave their opinions and took their time today to listen to everything that happened today. I also really want to thank the staff who has put just absolutely a ton of time in over the last, since this issue cropped up a few months ago. And so really, I mean, they have just been working their fingers to the bone. And then finally, I really want to thank each of the board and commission members for taking the time today and giving your feedback to the City Council. They'll be taking a look at all of this information, I think, on the 14th, right? Is that when we're going back with this? 21st is when they'll see all this information, and everything will be posted up on the website. So thank you so much for your time today. Have a safe evening.